首讀
Government Bills First Reading Evidence Amendment Bill 2026 Inland Revenue Amendments Preferential Tax Regimes for Funds, Family-Owned Investment Holding Vehicles and Carried Interest Bill 2026 Inland Revenue Amendments Tax Concessions for Shipping-Related Activities and Physical Commodity Trading Bill 2026 Second Reading Secretary for Justice Deputy President, I move the second reading of the Evidence Amendments Bill 2026. The bill seeks to reform the common law rule against hearsay evidence in criminal proceedings. Hearsay evidence refers to an out-of-court statement offered to prove the truth of the matter asserted. Under existing law, hearsay evidence is generally inadmissible in criminal proceedings, unless that evidence falls within one of the common law or statutory exceptions to the rule. The purpose of the hearsay rule is to ensure that the witness's credibility and accuracy can be tested in cross-examination by all parties. However, the hearsay rule has been the subject of widespread criticism over the years from academics, practitioners, and the bench for its rigidity, complexity, and unclear exceptions. In Hong Kong's civil proceedings, the common law hearsay rule was abolished as early as 1999 and replaced by a statutory framework. However, in criminal proceedings, the hearsay rule under the existing common law system has yet to be reformed. In practice, the inadmissibility of hearsay evidence that is otherwise cogent and relevant to the determination of the guilt or innocence of an accused sometimes results in the exclusion of evidence which by standards of ordinary life would be regarded as accurate and reliable. This can result in injustice. A typical example is cases involving vulnerable witnesses. For instance, children or victims who are unfit to give evidence in court due to their mental state or severe trauma. As they are unable to be cross-examined in court, their witness statements made to the police after the incident are often inadmissible in court, simply because they are hearsay evidence. To address the issue, many common law jurisdictions, including England and New Zealand, have already reformed the hearsay rule, replacing it with a conditional admissibility mechanism under statutory law. In Hong Kong, in order to reform the hearsay rule in criminal proceedings, the Law Reform Commission of Hong Kong, or LRC, published a report on hearsay evidence in criminal proceedings in November 2009, setting out a package of legislative reform proposals. To implement those recommendations, the government had previously introduced the Evidence Amendment Bill 2018, but was unable to complete the legislative process before the end of the term of the 6th Legislative Council, and the bill has lapsed. Subsequently, the Department of Justice conducted a comprehensive review to re-examine the LRC's recommendations. We have carefully considered the views received during the consultation on the 2018 bill and the subsequent discussions in the Council. Taking into account the latest legal and policy developments, this bill has been drafted. The bill will add a new part to the Evidence Ordinance, Cap 8, to regulate the admissibility of hearsay evidence in applicable criminal proceedings. In proceedings covered by the new part, subject to preserved common law exceptions and other statutory law provisions, hearsay evidence may only be admitted by the court through three routes. First, the prosecution and the defense make an agreement to admit hearsay evidence. Second, the party intending to adduce hearsay evidence serves a notice of hearsay evidence which the other parties do not object. Third, where a party intending to adduce hearsay evidence serves a notice of hearsay evidence and the other party serves a notice of objection, the court subsequently grants leave to admit that hearsay evidence after considering the relevant statutory conditions. As the first and the second routes are based on agreement between the parties and the absence of an objection, they are, by their nature, relatively straightforward. The court's approval is not required for the admission of hearsay evidence. As for the third route, where there is an objection to the admission of hearsay evidence, the court's approval is required. On the court's decision to grant leave for the admission of hearsay evidence, the bill sets out a number of key conditions, including the condition of necessity, the condition of threshold reliability, and that the probative value of the hearsay evidence must outweigh any potential adverse effects on either party. On the condition of necessity, the court may only consider admitting hearsay evidence where the witness is genuinely unable, for objective reasons, to give evidence through oral testimony, rather than simply unwilling to do so. For example, the witness has passed away or is unfit to give evidence in person or by any other acceptable means due to age, physical or mental condition. The party making the application bears the burden to prove that the necessity requirement is met. If the applicant is the prosecution, the standard of proof is beyond reasonable doubt. If the applicant is the defendant, the standard of proof is a balance of probabilities. As regards threshold reliability, the court must make an overall assessment based on factors such as the nature and content of the statement and the circumstances under which it was made, so as to determine whether there is a reasonable assurance as to the reliability of the hearsay evidence. Compared with the 2018 bill, there are a number of enhancements in the new bill. First, the bill expressly stipulates that the new mechanism does not apply to cases involving national security. Such cases will continue to be subject to the existing rules on hearsay under common law, so as to minimize the risk of cases being manipulated or influenced by false information, and to underscore the constitutional duty to safeguard national security. Second, the bill confers clearer procedural discretion on the court, enabling it to modify procedural requirements in light of the circumstances of individual cases. For example, by appropriately adjusting the time limits for giving notice and allowing notice to be given orally before the court. This will make the court more effective in dealing with unforeseen circumstances and ensure that no party loses the opportunity to apply for or object to the admission of hearsay evidence simply because of failure to follow the procedures strictly. Third, the bill refines the mechanism for the subsequent exclusion of hearsay evidence. Even if the court has previously admitted a piece of hearsay evidence, it may, upon application by a party, exclude that evidence if it subsequently considers that its continuous admission would be detrimental to the administration of justice. Following the exclusion, the court may, depending on the circumstances, adopt proportionate remedial measures to prevent a miscarriage of justice. The DOJ has issued a consultation paper and a draft bill in last December to seek the views of various stakeholders, including the judiciary, legal professional bodies, and university law faculties. They generally support the legislative proposal. In March this year, the DOJ also briefed the Legislative Council Panel on Administration of Justice and Legal Services on the consultation process and policy issues of the bill. Members expressed their support for the bill. President, as I have mentioned, the hearsay rule has long been the subject of criticism. There is a genuine need for Hong Kong to comprehensively reform the common law hearsay rule in criminal proceedings so as to establish a modernized and codified system that better meets the practical needs of our criminal justice system, whilst keeping pace with developments in other common law jurisdictions. The reform proposals seek to strike a balance between avoiding injustice arising from overly rigid rules and safeguarding the interests of the accused. Where a witness is generally unable to give evidence, the court may admit suitable hearsay evidence at its discretion, provided that the strict thresholds of necessity and reliability are met and the probative value of the evidence outweighs any potential adverse effects. This will enable those who are unable to appear in person or give evidence in other acceptable forms, particularly those who are unfit to give evidence due to mental health conditions or severe trauma, to still have their case heard by the court. This will ensure a fair trial where the truth is revealed, the defendant's rights and victims' interests protected, and society's expectations of judicial justice met. I so submit I implore members to support the bill. Thank you, Deputy President. I now propose the question to you that the aforesaid bill be read the second time. In accordance with the rules of procedure, the second reading debate is adjourned, and the bill is referred to the House Committee.
Secretary for Financial Services and the Treasury. Deputy President.